Ohio. I'd like to reserve 3 minutes of rebuttal time. The reason we're here today is because clearly there are many ways to interpret the rape sentencing statute in Ohio. As you can see, we have two panels in the same court that came up with completely different determinations. The two issues here today are whether if a judge gives a 25-year sentence, 25 to life sentence, without having a jury finding, does that violate Sixth Amendment right to a jury trial? Second issue is whether a judge has to make findings on the record if they make that sentence. The first thing that I think you have to look at, Ohio's sentencing statute is unique. I mean, Ohio's rape statute is unique because in the very body of the statute, the jury's verdict authorizes a sentence of life without parole, without any judicial findings at all. It is not a graduated scheme that starts with a minimum and then increases. It starts with life without parole.
So counsel, you can be sentenced to life without parole with no showing of force whatsoever.
Yes.
Okay, so in fact, there does not even need to be testimony about force.
When you have, yes, and it's in this case, when you have the rape of a child under the age of 10.
That's what I mean, a rape of a child under the age of 10 under these circumstances. And yet the state is saying that there should be the state is saying that you don't need that showing of force, or you don't need that finding of force by the jury in order to give the least level of sentence for this crime.
In order to give the least?
Well, the 15 to life is the least
yes.
level of penalty, correct?
Correct.
So you're saying in no instance do you need to have a showing of force except 25 to life?
We're saying that 25 to life is when there is evidence of force, but that a judge can make that finding without a jury having to make that finding. The way that the statute is written, there's nothing that says that statute would have to be, that finding would have to be made by a jury. The statute, did not stop and make life without parole mandatory. It then refers the judge to RC 297103. But that statute itself states if the judge decides to be more lenient, wants to decrease the sentence, you refer to that statute and you can make one of the following choices. It does not make sense that it would be more difficult for a judge to reduce a sentence, be more lenient, and have more restrictions on the sentencing.
Counsel, can I ask, we've talked a little bit about the maximum potential sentence, which is life without parole. Let's talk about the minimum potential sentence, if we can, under the language of the statute. As I understand it, 2971.03B1 says that if the court does not impose life without parole, it shall impose a sentence of what amounts to 10 years to life, except as otherwise required in subsections B or C. So that suggests that subsection C can impose, under certain circumstances, requirements of a 25-year to life sentence. And I guess my question is, when do those requirements kick in? Under what circumstances does the C subsection require a 25 to life sentence?
It does not, under my reading of this, and as the Bowers II court stated, it is giving the judge sentencing options.
The language, how do you handle that language in the statute that says except as otherwise required in division B or C?
Yeah, shall impose one of the following, which is what gives the judge the choice of B or C.
How do you respond to opposing counsel's argument that it would be nonsensical to say that where force is used with a 12-year-old, the minimum sentence is 25 years, but with a 9-year-old, the minimum sentence is 15 years, which I think is your reading of the statute.
First, that shows a choice by the judge not to give life without parole. That's the starting point. If some situation and some facts occurred where you have a sentence for a person who's the victim is under the age of 13, and I think you're talking about, they made the point that you could get a harsher sentence than if you were found only to have raped a child under the age of 10.
Right. Well, I mean, for the 15-year to apply, you have to have raped a child under the age of 10. But for the force to apply, well, force applies whenever you use force. So if we accept your reading that both of those options are on the table for the judge, where both apply, then it would seem nonsensical to say the minimum sentence is higher for a rape of a 12-year-old than it is for the rape of a 9-year-old.
I think the court has options in how they would sentence in that situation. And there are so many different factual scenarios. I don't think you can make a blanket statement about because it appears nonsensical. It appears nonsensical that a judge starts with life without parole and then is supposed to go through more steps, and a jury must be brought in when that judge decides to be more lenient. That is what appears nonsensical. And there's nothing in the statute that states that has to happen.
Counsel, was the use of force part of the indictment?
No.
Why is that?
Because, well, I can't tell you exactly what that prosecutor had in mind. Some prosecutors will add a specification of force. But you had rape of a child under the age of 10.
Well, wouldn't that always suggest that this force, I mean, a child under the age of 10, certainly, if you don't say force, then you're saying consent.
No. Well, I'm sorry. I disagree, because the statute is when you rape a child under the age of 10, nothing in that statute says that the child has consented. The statute states, it doesn't even say without consent. It says,
yeah, I understand that. I think that I would have some criticism of the statute, but that's not really what we're here to discuss. I'm just wondering why, given the testimony, given what was known about the case, that there wasn't a force element in the indictment.
I can't speak exactly to what that prosecutor did at that time, but I know there are many prosecutors who are saying when you have force, I mean, when you have the rape of a child under the age of 10, as this court has stated, it would be hard to imagine any scenario where force was not involved. And they do not want to add an extra element of proof, and they feel that it could confuse a jury when you have a spec for under the age of 10 and you add on force. If this court chooses, if Bowers 3 is adopted, the state can then spec every case with rape of a child under 10. We can spec with force every child under the age of 13, except those few cases where some children that are older were sexualized at a young age. And when they testify, they will say, I did consent to this because I was taught that's what you do with your father. It's generally, you have girls and often it's a father or a parental figure. And in that case, because they say that, then we would not have force. But in the majority of cases under the age of 13, in all the cases under the age of 10, force is used. If
But
it's a parental,
counsel, would that necessarily be true? Because this court has said that just the showing by the state of just minimal force is sufficient. And if you had a parent figure abusing a child, that would be enough under our current case law to prove force, correct?
yes, and that is without a force specification. If you're talking about Eskridge and Dye, that was the
Right.
point they were making. That it is so minimal what you need to be, the state needs to show in terms of proof. In this case, without the spec or the additional finding, the record is replete with the victim. She was 9 years old when she testified. She was 6 years old when this abuse started, maybe even younger. She says age 3 to 6, but from the acts in the indictment, it was age 5 and up. She was 9 years old, and she clearly testified to force of many specific acts.
Counsel, what about the element of serious physical harm, which is also an element under the C subsection, along with force? If the state establishes either one, there's a required sentence, 25 to life. Your friend argues. Is serious physical harm to be read in parallel with the force element? Are you saying that even if a jury, for example, were to find that there was serious physical harm in the course of the rape of a child of under 13, the judge is not required to impose a sentence of 25 to life?
At what age? Would 15 to life still apply? Was if
Under 13.
Whether the judge, well, then the judge would not have the option of 15 to life.
And
you
the judge
repeat
would
that?
have to impose, I'm sorry.
Would you repeat your answer, Ms. Lapp? I didn't hear it.
If the question is whether a person is indicted for raping a child under the age of 13, and there is a spec of serious physical harm that is found by a jury, does the court have to impose 25 to life? Is that the question?
What's your answer?
Yes. I don't.
But what if it was 10 years old? I think that's the.
Right.
Then I think we're in the same position. The judge still has the option of giving 15 to life or 25 to life, because nothing in the statute says that the statute is written in such a way, because you start with life without parole. 297103 says the court may choose one of the following. I think the judge still has that option.
What if we don't agree with your statutory reading that it's a middle option? What if we agree with the defense that once you find force, the minimum is 25? In that, if we accept that statutory reading, then is there a constitutional problem? I mean, if we accept that statutory reading under Allende, does the finding of force have to be made by a jury?
I may not be pronouncing it right. Are you talking about Elaine, which came after Apprendi?
Yes. I'm probably not pronouncing it right, but go ahead.
I watched in State v. Carnes, the justices pronounced it Elaine, or counsel did. Elaine is not violated because in Elaine, you started with a minimum crime. The federal sentencing statute then had added on in a graduated way higher sentences based on different facts. And the judge was finding them. And they said that created a new aggravated crime. Here, it does not, this statute, it does not create a new aggravated crime if a judge, given the option of 15 to life or 25 to life, chooses 25 to life.
But yeah, but what if we don't agree with the option of 15 on the table? Then does the finding of does the finding of force have to be made by a jury? What if we don't agree with your statutory reading?
If you agree with the Bowers 3 reasoning, that is what you would find. And in that case, what happens, I'm surprised that the defense bar isn't speaking up about this, because then you're taking away the option of 15 to life. We can spec then, if that's what this course decides, because there is a lot of misunderstanding of these statutes. We will spec every case of the rape of a child under the age of 10. We'll put that force spec in. What that means is the state is going to bring it up in opening statement, if that's what they intend to prove. They will ask a lot of questions with the witnesses, bringing out that. And then on closing, we will emphasize force. And if that is the reading, that it would take 15 to life off the table. For Mr. Bowers, he would have an advantage. He will be considered for parole 10 years sooner than the way he's sentenced now, if that's how this court rules. He could be considered, it's still a life sentence. All of these are life. But he could be considered at 15 years instead of 25. But for everyone else down the road, it's going to take off the 15 to life option, which I think the way the statute is written now is available to trial courts.
Doesn't that make sense with your argument that it's hard to imagine a scenario when a 10-year-old is sexually assaulted and that force wasn't used? So doesn't this boil down to a charging mistake? It should have been charged with the force element?
I agree with everything except the last statement. I think because it does not have to be charged as force, because in every situation of a child under the age of 10, force is inherent. And strictly, when you have a parental figure telling a child to do something, there is force inherent because of the psychological factors. It's there. That's why you don't. I guess what you're suggesting is in every rape case, then we would have to spec for force when there's a child, whether they're the victim is under 13 or under 10. And if that's what this course decides, then that's what we will do. I don't think that's what the statute as written requires. I'm almost down. Didn't I ask for 3 minutes rebuttal?
All right, we can save the remainder. Counsel? You'll have to unmute yourself.
Thought I was prepared for that. Good morning, everyone. Chief Justice O'Connor, Justices, Ms. Lapp. As I know you've read in my brief and also in the amicus that was submitted, we don't agree with the state's interpretation of this particular statute. If we go with what the state is arguing, it basically gets rid of the sub B section of the statute. There's no reason why, if force is always presumed, that there would even be a 15 to life option. The General Assembly specifically enacted that section that if a child is raped under that 290702A1B, if we take off the life without parole option, which is certainly the trial court's prerogative, then we're looking at 297103B1 and looking just at that statute. It doesn't matter what happened under 290702. We're looking now at 297103B1. And the question is, which one of those sections applies? And I think they're all very specific. The A section is the default. If there's a rape of a child under the age of 13, and there are no other specifications in either the B or C subsections, then we apply 10 years to life. If the child is under the age of 10, and there's no force that was specifically found, then we apply the B subsection, which is 15 to life. If there is force or threat of force or the other components of the C section, then we apply the C section. So we are looking at mandatory minimums for the B and C section. If those don't apply, then we default to A. The legislature would not have made that specific B subsection if it did not expect the trial court or the jury to prove force, because otherwise it would be a nullity, as I argued in my brief. Because if as Ms. Lapp argued, force is presumed in every case for a child under the age of 10, there would be no reason to use that subsection.
Counsel, would you agree that there's no element of force that needs to be shown in order to get life without parole? No, for a child under 10?
I agree that if there's a conviction for rape under the A1B section, the court has the ability under that section to impose life without parole without any other findings. I would agree.
Does that make sense then to have the delineation in B and C?
Well, I'm not sure why the legislature did this. And as Ms. Lapp said, I think this has caused a lot of confusion for a lot of practitioners and probably trial courts as well. I think what the legislature was doing is saying, okay, if there is a violation of this section, then the court can do life without parole. If the court does not believe that that is appropriate, then they, I hate to say, use the word forget that part of the statute, then we're focusing solely on 297103, as if the other statute did not exist. So then if we're just looking at what is required to sentence under that section, then we're looking at the different findings. So I think
I'm sorry, counsel, why wouldn't it be reasonable for the legislature to say, if you rape a child under 13, the judge can impose a sentence of life without parole, but if there is serious physical harm, or if there is force used, for example, then in no event may a judge impose a sentence of less than 25 to life as the minimum.
I guess I don't disagree with what you're saying, Your Honor.
All right, and so when I see language in your brief saying that if there's force used, then the trial court may impose the mandatory minimum sentence of 25 years, you mean that the court must impose that mandatory minimum if there's force shown and found by a jury, and if there's serious physical harm?
I agree. When I was preparing for today's argument, I did use the word may, and I should not have. That should have been must. I agree that if there is force found, then the C section applies as the mandatory minimum. Just as if there is no force, and I think that does need to be an express finding, then the B section would apply if it's a child under the age of 10. But again, that also has to be a specific finding. I don't think we can presume the age requirement either, because then we default to the A section if there's no specific finding by the jury. And that goes back to, I think the General Assembly was very specific in, if they want to have those enhanced penalties, there have to be those specific findings. Otherwise, we do default to the A section, assuming the court is sentencing under 297103. So, and I know it may hurt the defense bar potentially, if the state is going to put the force element in every single indictment. But that is what is required. The judge cannot make that determination under the Supreme Court's rulings in Alene and more specifically Hayman, because we're increasing the mandatory minimum sentence. So I don't have any additional argument on those particular issues unless there's questions.
Thank you.
Thank you.
All right, Ms. Lapp, you've saved, let's see, a little over 2 minutes.
Yes, Your Honor. I still go back to the fact, especially Judge Nelson with questions you were asking, that as the statute is written right now, the court is given options. That's how the 297103 was written. And that's why it is not an absolute that a court must do this or must do that. You have to keep going back to the fact that the judge can give life without parole with no findings at all. There had to be a reason the legislature did that. And nothing in the rest of the statute says that there have to be findings made. I don't know if it's completely applicable, but just in the past 2 weeks, this court decided State v. Taylor and said it's not for a court to speculate about what the legislature intended or to rewrite it. And I know you have not suggested rewriting it, but that's the problem in a statute like this and in a case like this. There are, as I said, so many ways to interpret it. But I believe as the statute is written now, it gives the judge the option of 15 or 25, even if force was found by a jury, which here it was not, the judge still would have the option of 15 or 25 because that's the way the statute was written. And that's why I'm asking that you adopt the reasoning in Bowers too.
Thank you. Thank you, ladies. We'll take the matter under advisement and you'll be notified of our decision.
Thank you, Your Honor.
Our second case this morning is 2018-968, the State of Ohio versus Sean M. Great. For the appellant, Mr. Gallick.
So, Your Honor, I would ask to reserve 10 minutes for rebuttal.
Proceed.
I would ask for 10 minutes of rebuttal.
I heard you.
Okay.
Proceed.
Madam Chief Justice, may it please the court, Donald Gallick and Don Hicks on behalf of defendant appellant Sean Great. We come before the court today on obviously a very disturbing case of multiple murders and something we won't be arguing today. No one is going to suggest that the police arrested the wrong person. We know that the right person was apprehended. The prosecutor indicted the correct persons. That's not before the court today. Having said that, there are many legal and constitutional issues that came up during this trial. Quite a few. Going to the first two propositions of law, there's issues that all interrelate regarding venue, the gag order, and jurors who, this being a small area, Ashland County, Ohio, who knew the victim, and several others said, oh, I saw this on television, I read about this, I saw he killed women. There was no effort from trial counsel to try and exclude these jurors. They stayed on the jury. One recognized one of the testifying victims, who I'll identify as LS only, needed time to calm down, realizing that she'd met the victim. And not only did these jurors, of course, go and vote to convict, but they would subsequently, in the penalty phase, vote to issue a sentence of death. We suggest there's several constitutional concerns as to those two propositions of law. Moving on to probably a broader issue regarding ineffective assistance of counsel and what some courts call cumulative ineffective assistance of counsel. You have two trial attorneys who perhaps were overwhelmed on this case. There was so much evidence as to guilt. They attempted to file a not guilty by reason of insanity. It was filed. And then prior to the trial, they withdrew it. And you could say, well, okay, that's trial attorney. That's the tactical decision that they made with their counsel. But we find out later in the sentencing hearing that the neuropsychologist they hired, he tells the court, well, I haven't completed my scans. I haven't completed my report. I'm only preliminarily done, only half done with my information. At this point, the not guilty by reason of insanity has long been withdrawn. And it comes out through trial that there's quite a bit of testimony suggesting that there was a mental health issue to be concerned here. I mean, first, Detective Mager interviews him 4 or 5 times. Miranda warnings are given. He has no interest in an attorney, doesn't understand what the problem is. He's happy to tell anyone. Now, happy is the wrong word because there's no emotion you can see from the interviews. But he says, yeah, I took these women, I restrained these women, I raped these women, I killed these women. At one point during his interview, he's asked, when can he go home? Like, when is this going to be over so I can go about my business? Not seeming to understand that there's legal problems when you engage in this sort of conduct. There was also testimony from the surviving victim. She said that Sean Gray told her that God sent him to Ashland. God told him to go to this abandoned house and meet women. And then Detective Mager said during one of her interviews that she had a conversation with Sean Gray, how he might end up marrying LS, that the surviving victim, perhaps one day they will get married, despite of the restraining and rape and probably could have been murdered at some point. It also comes out during the trial testimony from the surviving victim that when she escaped and she got access to a cell phone, she picks up the cell phone to call the police. Sean Gray wakes up. Sean Gray sees that she's calling the police. She thinks this is it. I'm going to be killed. He knows I'm talking to the police. That's it. Sean Gray says, I'm tired. I'm going to go back to bed. Doesn't understand there might be a problem with her calling the police, that this could somehow lead to him getting arrested and put on trial. He has no concept of this. Unfortunately, not guilty by reason of insanity was never presented to the jury. The plea was withdrawn before the trial. And going to the mitigation phase, Dr. Fabian says, well, you know, we did some brain scans. I didn't have enough time to complete it. Really, we need a continuance, to which the trial judge is not very happy and admonishes trial counsel why this wasn't brought to his attention before the middle of the mitigation phase of the trial. These are great questions. It appears that the defense attorneys, at what point do they become non-participants in the case? There's 50 prosecution witnesses. They don't cross-examine 32 of the 50 witnesses. You could say, well, some of these witnesses, their testimony was ancillary, their testimony just kind of background. There were detectives who testified. There was testimony about him talking about voices from God, about Detective Mager saying, you know, he said that he was going to marry the victim. That sounds like something we should get into on cross-examination. When the direct is over, trial court says cross-examination. No, thanks, Your Honor. We don't have any cross-examination for this key witness. Defense counsel waived opening statement during the guilt phase. They waived opening statement on the penalty phase. During the penalty phase of the trial, they only called 2 witnesses. One being Dr. Fabian, who said, well, I haven't really completed my work. Too bad I didn't have more time to do more neural scans and figure out more what's going on, which rightly drew an objection. And the trial court said, well, that's not for us to get into with the jury about how you didn't have time. That's something trial counsel maybe should have brought to the court's attention before we're, you know, in the middle of the penalty phase of a capital case. And then the only other witness that they put forward was Sean Gray's sister. She attempts to testify about what their home life was like, about abusive family, about alcoholism. There's an objection to that. The trial court excludes that, says, well, that's hearsay. We can't get into that kind of hearsay here. That goes against not only, I say, Ohio Rule of Evidence 101C3, it goes against a long list of federal cases. I mean, there's the Sixth Circuit case, Skaggs versus Parker. There's the U.S. Supreme Court, Green versus Georgia. I think even Lockett versus Ohio gets into penalty phases in death penalty trials, where they say you got to give wide latitude when we're talking about life or death sentence. I believe that was codified.
Counsel, didn't Dr. Fabian provide a testimony about the dysfunctional childhood and, his complex trauma, his personality disorders? Wasn't that all on the record?
There was some of that testimony on the record, but I believe that there was an objection. The trial court told the jury to disregard much of this is based on hearsay, and that there is, I think,
from the doctor. Wait a minute, the trial court said that about the doctor's testimony.
I believe some of it they did, Your Honor, because there's a point in the briefs that we wrote that at some point they're saying Dr. Fabian, a lot of his diagnosis is based on hearsay statements that is in his diagnosis. There was multiple objections during, and again, there's only 2 mitigation witnesses during the whole penalty phase of the trial, and there were objections to both witnesses, Dr. Fabian and Sean Great's sister, saying this testimony about his mom might have worked as a stripper, he might have been exposed to sexually improper behavior from his mother at a young age, and alcoholism. That's based on hearsay. Well, maybe it is based on hearsay, but there's a long line of cases saying in a penalty phase of a trial, you give a defendant wide latitude to put relevant facts about his character and history in front of the jury so they can make a decision if a death sentence is appropriate. Or I believe the language that comes out of the U.S. Supreme Court and the Sixth Circuit is any penalty other than death. So maybe the jury feels bad for the childhood that Sean Great had to go through, but they were instructed not to regard that testimony by the trial judge. Maybe they come back and say, you know what, we're just going to do life without parole. We don't know. Much of the testimony was objected to, and the trial court sustained those objections and even gave a cautionary instruction to the jury at one point to not consider hearsay testimony during the penalty phase. There again, and many of these issues interrelate, because when you're going to this trial, innocence, a not guilty verdict on itself is not going to happen. There's no argument that someone else committed these crimes. Sean Great tells anyone and everyone that he committed these crimes. He doesn't want a lawyer. He'll tell anybody. Doesn't understand why there's an issue. All you have in this case is mitigation or Sean Great's mental health condition. You withdraw the NGRI plea so that the jury can't hear that. Mitigation is all you have. Mitigation is all you have. And you go into mitigation, they call his sister, much of her testimony doesn't come in. Dr. Fabian says, well, I didn't complete my neurology scans. I don't really have time to provide a complete picture of who Sean Great is. And then some of his testimony is based on hearsay that he heard about prior bad family problems, alcoholism, and what have you. So you basically have a mitigation case where there's virtually no preparation, and it was the only thing that you had. Many cases have come before this court, many capital cases have come before this court, where whether it be the attorney's strategy or maybe a client is demanding it, I didn't commit these crimes, I didn't murder these people, and the lawyers focus on that. Maybe that's right, maybe that's wrong. This is not one of these cases. This is something where the defendant says, everyone, yeah, I killed these women. I raped these women. Sure. In fact, at one point, I believe Detective Mager asked him, could you go through all that again and act it out? We'd like to videotape you doing it. He goes, sure, I'll act it out, whatever you need. I mean, is there a problem? No concept that there's legal problems in what he's saying, which definitely goes into Ohio standard for not guilty by reason of insanity, which is sort of a McNaughton ALI product test all rolled up into one. Did the defendant know the wrongfulness of his conduct or not due to a mental disease or defect, I believe is what is in the statute. That was all available to defense counsel, but they withdrew it. And whether they withdrew it because Dr. Fabian said, I don't have enough time to do my work, or because of some other reason, we don't know. That's not in the record. But what we do know is that's in the record is the only thing these defense attorneys could have done is focus on mitigation. And what you get is 2 witnesses, a sister and a doctor, and much of their testimony is blocked as being hearsay, which again goes against a long line of federal cases, as well as some cases out of this court that is, I think, brought in the statute that said, look, a defendant is to be given wide latitude in putting forth character and family information in a capital sentencing trial. Want to move on to some. I mean, there's other ancillary sentencing issues that I don't want to spend too much time on. But in the mitigation closing argument, they waived opening, but they did do a closing, and they said, hey, Sean Great, he's a stand-up guy. He's honest. He tells everyone about his murders and the crimes he's committed. Is that a mitigation strategy? I mean, can you say that that's within the bounds of normal legal representation to say, well, I'll just tell the jury, this guy that you heard who's killed multiple women, raped women, a surviving victim comes in here who's devastated. Hey, my client, he's a stand-up guy. He's honest. He'll tell you about every woman he's murdered. He's happy to tell you all about it. What a great guy. Let's not give him the death sentence. Obviously, it wasn't effective. Is that the strategy that I know many courts, this court, all courts say that we're not in the business of reviewing trial tactics, and maybe there's a reason why a trial attorney made that choice. Is that something that's within the standard of reasonable expectations of an attorney to go and say, hey, my client killed women, raped women, but he's a stand-up guy, he's an honest guy, and you should at least give him some points for being honest about these horrific crimes that he's committed. That was their mitigation. That was their whole case. And for much of the case, as we brought up, they were silent. They waive opening, they don't have cross-examination, they don't argue about merger, they don't argue hardly anything in the case. This is all you get. At what point do we have a Sixth Amendment deprivation? And again, I asked the court to look at all of these issues cumulatively. If there's no other questions, I'd reserve the balance of my time.
Thank you. Mr. Mayor?
May it please the court, relative to the characterization of some of the factual issues by Mr. Gallick, the record would contradict quite a bit. There's the pertinent facts relative to Dr. Fabian and this issue with a second round of brain scanning are spelled out in the state's merit brief, but I would note that the record does not have any request for continuance for a second round of brain scanning. In fact, Dr. Fabian, through OSU Hospital, specifically Dr. Charest, an MRI medical doctor at OSU Hospital, conducted brain scanning. And as far as the record that evidence was not presented. It is fair to assume that because the brain scanning evidence from Dr. Charest was not presented, that it simply wasn't favorable to Mr. Great. And it was a fair inference that the brain scanning evidence from OSU Hospital did not enhance the state's case, and it was a tactical decision not to present it. The issue came up in that context with Great's counsel, through the assistance of Dr. Fabian, seeking a brand new second round of brain scanning, which the trial judge made every effort to accommodate. There were hearings. The bottom line on that second round of brain scanning is the trial judge put on entries to accommodate it. But what happened was this mindset consulting group from California no-showed on a hearing about proceeding with a second round of brain scanning. Once they no-showed, and the defense, as far as the record can tell, defense counsel were caught flat-footed with this outfit from California no-showing on a status conference to proceed with the second round of brain scanning.
Counsel, was that to be a Daubert hearing?
It appears that the way the record is set up, once the California outfit presumably would be able to conduct a brand new second round of brain scanning out of Cleveland Clinic and then get some kind of results and then decide what they're going to do with it. If they're going to present it, then there would have been a Daubert hearing. there would have been a Daubert hearing earlier if Great had intended to present the brain scanning from OSU Hospital through Dr. Charest, but he didn't. So consequently, it was the record, at least at this stage, at this direct appeal stage, the record shows that Great had a complete first round of brain scanning that he didn't use.
All right, so you're saying this would have been duplicative?
It would have been at best cumulative, but more so, it probably, we don't even know, because the California outfit at least claimed they couldn't do anything whatsoever with the OSU brain scanning data. So it is a complete toss-up as to what's going on. So, and during that video here, the one prior, which there's a transcript of it, Dr. Fabian was specifically asked if the second round of brain scanning could not be accomplished for whatever reason, would you, Dr. Fabian, still be able to proceed with your mitigation testimony? And his answer was absolutely. He is not a brain scanning doctor. Dr. Fabian is a neuropsychologist. The most that he could, the other thing about it is Dr. Fabian, has no expertise in brain scanning. His testimony was not influenced one way or another as to whether there was in fact brain scanning. If brain scanning evidence was going to be presented, it would have had to have been by somebody else, another expert, not Dr. Fabian. Dr. Fabian has diagnostic testing that he uses as a neuropsychologist, none of which is brain scanning. No neuropsychologist uses or can interpret or be any type of an expert for brain scanning. That's much more of a medical issue, an MRI, so at any rate.
So counsel, do you dispute that Dr. Fabian felt that he did not do a complete analysis or that he needed more time or something more?
Yes, Your Honor. The state's position is that the record absolutely contradicts any notion that Dr. Fabian could not proceed with his testimony in the absence of a second round of brain scanning. And in fact, we can rely on what Dr. Fabian said, specifically to Prosecutor Tennell's question that can you proceed, Dr. Fabian, if the second round of brain scanning doesn't go through? And his answer was absolutely, meaning that he can proceed. Granted, once he gets on the witness stand, there was a brief skirmish about the second round of brain scanning that didn't go through no fault of defense counsel. Their witness was a no-show. So at any rate, the trial judge simply said, we are not discussing this issue now, is all he said. Dr. Fabian never once said he was unable to proceed. In fact, he said exactly the opposite. Now, with that, now in a related issue, I would like an opportunity to briefly discuss the idea that in fact the rules of evidence do apply during capital mitigation. Granted, it's relaxed. They're not to be strictly applied, but they absolutely do apply. Hearsay rules, it was actually, this case presents really a textbook example of the use of an appropriate use of hearsay rules by the trial judge when the Sean Great's sister, who, by the way, hadn't had contact with him for 12 years before the murders. Not trying to denigrate anybody, but Great did not have contact with his family. So the sister Barbara testified, and she said, she admitted, she says, look, I haven't seen him, it was, I think, for a 12-year period. Anyway, she says, it's just about talking about how her mother presumably was sexually abused, or there might have been some kind of history with that. When she says that, the sister says that, the state objected, hearsay, the trial judge sustained it. And when it came up with Dr. Fabian, because there's evidence rules that permit a person like Dr. Fabian to rely on hearsay if in fact it's kind of a history-taking part of his diagnosis. That was fully allowed. That was permitted. The experts allowed to say that. Sister Barbara was not. At any rate, what the issue in evidence admissibility in mitigation is, the hallmark is there's the offender background and circumstances of the offense that provide the touchstone for relevance and capital mitigation. And what that does is that it means that things like what happened to the co-defendant, because it's not offender background, if my co-defendant got lesser penalty, it's not relevant in my capital mitigation because it's not part of my background or the circumstances of the crime. That's what is the baseline for relevance. You then gauge admissibility in that context, offender background and circumstances of the crime. But otherwise, the rules of evidence fully apply. This is, it's a long-standing proposition, Lockett versus Ohio, Tenard versus Dredke. The rules of evidence do apply in capital mitigation. And then although the statute 292904C says great latitude is to be afforded on admissibility questions, that's fine. And that was done in this particular situation. So I don't see that as being a viable issue for error. And unless the court has questions, the state would stand on its merit brief.
Thank you. Mr. Gallick?
Thank you, Your Honor. Your Honor, I don't think that the trial court can be blamed on any problems that there were regarding brain scans or Dr. Fabian's report. I agree that the trial court seemed to be as reasonable as possible and tried to ensure that they had sufficient time. But again, and I'll start throwing out some page numbers of the record. On page 3,669, 3,670, Dr. Fabian says, I have concerns with my mitigation report. Well, you have concerns with your mitigation report. The jury's sitting over here. We're doing our mitigation trial. What are your concerns? And then the prosecutor objects and they go to sidebar. And the prosecutor actually says, look, they're going to bring up that they didn't have enough time to fully, and what the quote is, lack of time to properly investigate. That's what Dr. Fabian's saying. He didn't have enough time to write a complete mitigation report. And then the trial court admonishes defense counsel, if this was an issue, why wasn't this brought to the court's attention before now? Which is a great question. Who knows what the answer is? Because at the beginning of the trial court says, is there any reason we can't proceed? And defense counsel says, no, we're good. This is a good time to proceed. You have to put this information in front of the trial court as soon as possible. You can't wait until the middle of mitigation trial. Again, it's a 2-witness mitigation trial, and say, oh yeah, well, there's some problems. We didn't have enough time. We didn't get the proper report fully done. So that's the issue as to that. As regard to the objection, hearsay to Dr. Fabian, not to the sister, there's a lengthy cautionary instruction that the trial court gave on page 3683 to 3684. And he advises the jury that a lot of Dr. Fabian's testimony is based on hearsay. And, you know, cautionary instruction like, hey, he's giving you hearsay testimony, you know, he doesn't strike it from the record, but he's kind of warning the jury, you know, whether the rules of evidence apply to this proceeding or not. There's a line of federal cases involving the 5th, 8th, and 14th Amendments in a capital trial. And I mean, obviously the 6th Circuit case, Skaggs versus Parker, Green versus Georgia, they don't mention any Ohio rules of evidence. I think Green versus Georgia did get into a Georgia hearsay statute or rule and said you got to be very careful using a state statute or rule to try and limit testimony in a capital case. But the trial court gives a lengthy cautionary instruction that if you read these federal cases is problematic, could be a constitutional concern, to tell the jury, well, watch out for what Dr. Fabian's telling you. It's based on hearsay. And as the state of Ohio said during their part of the argument, when the sister tries to give testimony about the abusive family and alcoholism and sexual abuse in the family, there's objections, and the trial court sustains that objection. And I understand the sister had not seen Sean Great for 12 years, but that's not really germane to anything, because the reason the sister is there is not how Sean Great was a year before the trial. The effort is to give the jury a picture of what Sean Great's childhood was like, what his relationship with his mother and family was like, and how did he turn into somebody who commits rapes and murders and doesn't seem to understand that there's a problem with that. The sister could have given that testimony. She was in the best place to give that testimony. I understand the state of Ohio saying, well, some of that was allowed with Dr. Fabian. Okay, despite the fact there was a cautionary instruction warning the jury about it. The sister witnessed this firsthand. The sister was there during their childhood. So she didn't see Sean Great's 12 years ago. At this point in the trial, he's 39, 40 years old. We're not interested in what happened to him when he was 35. We're interested in what happened to him when he was 8, 9, 10, 11. And that information was blocked. That was objections. The trial court sustained them. And this is certainly the federal line of cases. Any evidence that could give a sentencing jury an idea of the character or family history, that's just what we're talking about. That's what the 6th Circuit is talking about. That's what the U.S. Supreme Court is talking about. And that was barred by the sister. Some of it was allowed to Dr. Fabian, but the trial court gave a cautionary instruction. There are other issues. There's also in the sentencing entry, there's no statement of proportionality. That's certainly you could say a clerical defect in the sentencing entry. That's something I wanted to bring to the court's attention. If there are no other questions about the brief or the propositions of law presented, I would thank the court for its time.
Thank you. Thank you, gentlemen. We'll take the matter under advisement, and you'll be notified of our decision. All right, our third case this morning is 2019-1103, the state of Ohio versus David Carl Kinney. For the appellant, Mr. Gagan.
Chief Justice O'Connor, and may it please the court, I wish to reserve 3 minutes for rebuttal. By statute, Ohio grants every convicted felon the right to appeal their sentence except for 2. Through the good work now of the amicus curiae in this case, it's now undisputed that Ohio is the only state in the nation to deny appellate review of aggravated murder and murder sentences. This case, therefore, asks the court to determine whether the statute that imposes that unique sentencing practice, Revised Code Section 295308D3, violates Article 1, Section 9 of the Ohio Constitution and the 8th Amendment of the United States Constitution as a cruel and unusual punishment. But before I address the constitutional issue, I would like to address the question as to why. Why is it that Ohio stands alone in this particular sentencing practice? And again, the source of Ohio's anomalous sentencing practice is found within the statute's legislative history. Summarizing that, from 1996, July 1st of 1996 until March 2nd of 2005, Ohio had but one sentence a trial court could impose for aggravated murder and murder, which was 20 to life, under the former 29-2903. Consequently, when 2953-08 became effective on July 1st of 96 as part of Senate Bill 2's sentencing reform, it included Division D, which took away the right of appeal for anyone convicted of aggravated murder or murder. And I would submit that at that time, that was a rational choice. There was but one sentence, 20 to life, with no discretion for the trial court. One size fit all, everyone got the same sentence. There was nothing to appeal. To allow an appeal would have been to allow a superfluous act. But that changed.
Counsel, to allow an appeal based of the sentence is one thing, but to flatly deny an appeal for a host of other reasons, other errors at trial, etc., how is that justified?
Well, I believe, Your Honor, under D3, it was simply the sentence that for an aggravated murder or murder that was denied appellate jurisdiction.
So all the other appeals are on the table.
Correct, Your Honor.
Okay.
Correct, Your Honor. 2958 or 2953-08A grants the right to appeal a felony sentence in Ohio. And then D3 takes it away just for aggravated murder and for murder. And again, historically, as we're going through this, Substitute House Bill 184 in 2004 added additional discretionary sentences. We went from just 20 to life. We had 20 to life, 25 to life, 30 to life, and LWOP, life without parole. But for whatever reason, the General Assembly did not adjust its sentencing practice to permit an aggravated murder or murder individual that's been convicted of that to appeal their sentences.
Counselor, do you think it was just sheer oversight?
Your Honor, I know the amicus curiae have sort of said that there was no way that the General Assembly could have intended that outcome. I think part of the problem, though, with that, quite honestly, is that this court's opinion in Porterfield said that that statute meant what it said. And originally it was Division D. And when they amended it, they then made it, they separated it out because of a potential ambiguousness issue relative to it. So practically speaking, the General Assembly had to physically address that very issue. So I think from my perspective, for Mr. Kinney, I think it's difficult for us to say that they didn't think about it in terms of creating that statutory scheme, if you will.
Counsel, you in your briefs, you tend to rely also on Article 1, Section 1 of the Constitution. Was that actually raised below? Because the appellate court doesn't seem to think so.
Well, the answer to the justice's question is yes. I did raise that here. I do see this as a new federalism type of case where the Ohio Constitution provides a broader protection than the 8th Amendment alone. The issue was essentially raised below, but keep in mind, under Porterfield, the 7th District Court of Appeals had no appellate jurisdiction to consider anything relative to the sentence itself. So I submit that it has been raised, and I would also submit, as the amicus curiae pointed out in this case, that is not a new issue. We're not raising it. It may be considered a new argument, but it is not a new issue, and that is permissible. In fact, the state in Lingle versus State, another parallel case to this, has argued that it's more important for the court to get the law right on those types of issues. So the state has gone to great lengths to argue that we seek a declaration of a constitutional right of appeal to a felony sentence. We do not. That issue is well settled. There is no constitutional right to an appellate review of a criminal sentence. This court has agreed in State v. Smith on that. But Ohio grants that right of appeal statutorily, and then it further punishes only aggravated murder and murder convictions with a further punishment by taking that right that is statutorily granted to everyone else in the state convicted of a felony. They take that right away. And this raises an Eighth Amendment problem because, as this court and the Supreme Court have acknowledged, that once the right of appeal is established, even though it doesn't have to be established, but once it is established, then these avenues must be kept free of unreasoned distinctions that can only impede open and equal access to the court.
So that sounds to me more like an equal protection challenge. Was that raised?
So, Your Honor, the equal protection argument has been one that I'm sure the court has seen that the parties have gone a bit round and round with. I want to explain that. This is a good opportunity to do that. So, first of all, as the Supreme Court case law indicates, equal protection, because the Eighth Amendment is made applicable to the states through the 14th Amendment, they are said to be somewhat interwoven, both due process and equal protection within an Eighth Amendment analysis. So I don't, from my perspective, on behalf of Mr. Kinney, I don't see how one eliminates the other. They're interwoven, as the Supreme Court has said. I also think it's important to understand sort of the distinctions, if you will, of positions. I actually obviously have a real client. Mr. Kinney was sentenced to LWOP. And when you look at the LWOP analysis, it has problems in Ohio that I do believe violate both Article 1, Section 1, and Section 9 of the Ohio Constitution, as well as the Eighth Amendment, because LWOP allows one judge, one time with a discretionary sentence, and there is never another review of that sentence. And I do believe that that becomes an arbitrarily administered sentencing practice that is prohibited. That's different from, say, the amicus curiae in this, who are taking the broader view, where you would have, say, an aggravated murderer sentenced to 25 to life or 28 to life with a gun spec. My Eighth Amendment analysis says that because there is an administrative review available to those individuals, that the statute, D3, might survive an Eighth Amendment analysis and challenge for anyone not sentenced to LWOP. But I think LWOP is unique in this case. You have the whole issue about death is different, and I understand that. But in this particular circumstance—
Do we have to get to your argument at all? I mean, what about 2953.02? Doesn't that give you a right to appeal?
Well, that's certainly what the state has argued. They called that the general—
Well, they say they haven't. They've argued that. They say it hasn't, but—
Well, I understand. They raised the issue as to whether— I think in my understanding of it, the question is really, does the court have to address that issue before it gets to the constitutional issue? I would say no.
Well, if there's a right to appeal, there's a right to appeal. We kind of have to address that first.
Right. I understand that, Your Honor. I think quite honestly, ultimately, the Solicitor General's analysis is correct. There is, because D3 is a specific reference to aggravated murder and the appellate sentences, that would supersede the general appellate law that the justice—
Well, even under, if you say there's a constitutional problem, shouldn't we see if there's a statutory way to, before we get to this constitutional issue? I mean, isn't that?
Obviously, if the court can address an issue prior to reaching the constitutional issue, it is required to do so. In this particular case, though, I think you go back to State versus Porterfield, where this court said, D3 means what it says. It says there is no appellate jurisdiction for aggravated murder or—
But what does that language mean in 08 that says in addition to any other right to appeal?
Well, again,
and what's the language mean in 02 that says there's a right to appeal a criminal sentence?
Well, under what 151, the statutory construction, I believe, as you go through it, is going to say that the specific will control the general, and there's no question that 02.
Well, but doesn't it have to be a conflict for the specific to control over the general? I mean, is there a conflict here?
Well, it would be a conflict if
Why is that?
Well, if O2 says there's a right to appeal a felony sentence, and then D3 says there's no right to appeal a felony sentence in instances of aggravated murder.
It says there's no right to appeal under this section. It says, and the statute says in addition to any other right to appeal. That doesn't seem like a conflict to me.
Well, again, that would suggest that Porterfield would have to be overruled before you could get to that conclusion, Your Honor.
Huh.
So where that leaves us, I believe, is that well, let me do it this way. Let me address the Article 1, Section 1, the new federalism issue. I did not cite State versus Mole 149, Ohio State 3rd 215, which is a 2016 case, or Arnold versus Cleveland 67, Ohio State 3rd 35. That's a 1993 case. That is to my discredit. But it is relevant because this court has said on multiple occasions that the Ohio Constitution is a document of independent force relative to the federal Constitution. And relative to Mr. Kinney's LWOP sentence, Article 1, Section 1 gives every Ohioan the inalienable right to enjoy and defend their life and liberty. And under D3, there is no right to defend that life or liberty. Mr. Kinney, despite his conviction, I will say to anyone that will listen, is not an evil man. He had no prior issues with the law. He didn't have a drug problem. Yes, sir.
Didn't your client have a right to defend his life and liberty at trial?
Well, I would say to you, he has the right to defend his guilt or innocence at trial. But of course, sentencing then becomes sort of a separate phase of that prosecution process.
But counsel is entitled to argue about sentence.
Well, I think there's a practical issue, though, Your Honor. If D3 means what it says, as this court said in Porterfield, what difference does it make if you try to put on a sentencing issue? Because regardless of the sentence, it's non-reviewable, right? So, I mean, in some ways, why would a prosecutor ever charge somebody with a death penalty and give them the rights of appeal and the years of appeal, right? Why not just sentence them to LWOP, which is not, or any other sentence, which is non-reviewable, even if the judge in question was overtly using an improper motivation for the sentence or was not following Ohio's sentencing guidelines. There's right now, it is beyond review under the statutory construction, again, which Porterfield lays down. In looking at time, I would like to just reference a remedy in this case. I do believe that the remedy of severance is the appropriate remedy under Revised Code 150. I believe that this can be cured simply by striking Revised Code Section 295308D3 in its entirety. I understand the court might I think there is an interesting dichotomy, though. If the court were to make an Eighth Amendment analysis, it might not strike it all down because only LWOP arguably would violate the Article 1, Section 9 and Eighth Amendment. But the removal of that paragraph would fit in the larger equal protection argument that is advanced. Again, that's beyond my particular client, but it is within the realm of the amicus in this case. And they have agreed with that potential. It's a very simple, quick way to remedy what is clearly an unconstitutional sentencing practice. I would also say that Mr. Kinney, therefore, because there is no ability to appeal the sentence, once you're convicted, you're classified and regardless of your individual characteristics, your appeal is then beyond review. And so at that point, I think it has to go back to the trial court for resentencing to put on a full sentencing hearing at that point with all mitigating factors. And then we would proceed with the appeal, just as the state of Ohio provides for every other convicted felon in the state.
Thank you. Mr. Flowers.
Thank you, Chief Justice O'Connor, and may it please the court. I'd like to begin with a really important clarification and then a factual correction that goes to the why question. Why do we do it this way? First, the clarification. We agree that there's no right to appeal a sentence, but that does not mean these sentences are beyond review. There are several ways to do that And every single avenue would allow a defendant to capture the horrific scenario in which a judge gives life without parole versus parole after 20 years because of race or sexual orientation or something of that manner. And I would add that if they were to seek relief on that basis and the trial court erred in that respect, our office would be here arguing that the judge should be removed from the case and probably the bench. But putting that aside, what are these avenues for relief? First, a writ of mandamus. If the judge were to rely on something like that, there'd be a clear entitlement to mandamus relief for a resentencing before a new judge. They could also go directly to the U.S. Supreme Court with a writ of certiorari. You can seek a writ of cert from the highest court and the highest from the last state court that is able to issue a ruling. Finally, they can seek disqualification before the Supreme Court of Ohio. All that brings me to the why. Why is it structured this way? Well, because aside from the scenarios we're talking about where a judge relies on race or something, there is no situation in which the imposition of a sentence of life, of any version of a life sentence, without parole, with parole, will ever be arbitrary or unjustified. And I also want to correct, that brings me to the statutory history point. The amici, to some extent, though they walk back from this in a footnote, and Kinney both say that the previous version of the law allowed only one sentence for aggravated murder. That is false. I invite you to look at the law that was on the books at the time. There was one sentence for life without parole with no capital specifications. But if there were capital specifications, there was a range of sentences available: life without parole, parole after 25, parole after 30. So that entire argument that this was an oversight or something of that nature is built on a false premise. That is simply that it was not the law then, and it doesn't explain why the statute says what it says today. So the reason, again, the General Assembly did it this way is because they recognized, or at least they had a rational basis to conclude, that the truly egregious abuses of judicial power could be corrected through mandamus, through disqualification, and otherwise there was no reason to burden courts with bickering about whether a trial court should have decided to impose parole after some number of years or life without parole. Simply put, death is different. When you as an adult...
What was the range of sentences available to the trial court?
For aggravated murder?
In this case?
It would be life without parole after 20, 25, or 30. I'm sorry, life with parole after 20, 25, or 30, or life without parole.
So that gave the trial court a great deal of discretion. And presumably he, in making the decision he did, he applied 29-29-11 and 29-29-12, listened to the arguments. What did the state advocate for at the sentencing hearing?
Life without parole, and the court gave the reasons for imposing life without parole, which was...
So is there any other law on the books where a discretionary decision like that wouldn't be reviewable?
Well,
just to make sure there wasn't an abuse of discretion by the trial court judge in making that decision?
And I think the key point is it would be reviewable in mandamus, but what the General Assembly recognized is there will be no situation in which there will be just a normal old abuse of discretion that would justify an appellate court overruling a trial court who heard the witnesses, saw the defendant's demeanor, and decided that one version of a life sentence is more justified than another. Again,
but what about a constitutional question that comes from a life sentence? Say, I mean, I heard you say that, well, there really can't be an Eighth Amendment issue, but what if there was an equal protection issue? What if there was, discrimination based on race?
Right.
Do you think that took do you think there's no jurisdiction to hear that case in the Court of Appeals or this court, except on mandamus?
Well, except on mandamus, you could seek disqualification. You could go directly to the Supreme Court of the United States. I don't think there'd be a direct right to it.
What about the provision in the Ohio Constitution that talks about this court's jurisdiction over constitutional cases arising under the state or federal constitution?
Oh, absolutely. This court has jurisdiction over this case, and so it is able to review the question. But what it's doing is
isn't your view that that we don't have jurisdiction to decide these issues unless the Court of Appeals does?
Yes, that is our view. In an appeal, of course, there could be mandamus, and I don't see why that wouldn't be an adequate remedy here. It's effectively de novo review of the
what about the Ohio constitutional provision, though?
The Ohio constitutional provision says that this court will have jurisdiction, appellate jurisdiction, to review any criminal case. And the court will exercise that by reviewing the judgment below. But the only way to review that is to affirm it because they correctly held that they had no jurisdiction. But I would add that if this court does have jurisdiction to review the sentence, then his Eighth Amendment claim or any constitutional claim necessarily fails because it means he does have a right to an appeal, which is the antecedent question that's never been, that wasn't adequately briefed below.
I mean, why wouldn't we say that 2953.08 deals with challenges based on, say, the judge's use of discretion within the statutory mandated range, and under that section, those kind of decisions aren't appealable, but this court of appeals can still hear constitutional challenges?
Well, I think what the court could say is at least this, if it's true that at least the felony appeal statute does not permit reviews of abuses of discretion, then Mr. Kinney's claim fails and this court has to affirm, because he has not argued that his sentence is unconstitutional or that it was unconstitutionally imposed. He apparently wishes to challenge the exercise of discretion. So I think what the court could do is affirm the 7th District and say that at least in cases like this, where there's not an underlying constitutional challenge to the sentence, the appellate courts lack jurisdiction, and leave for another day what would happen in this, hopefully never does happen, case where a judge imposes a sentence based on race or sexual orientation or something of that nature. But back to the merits, the court granted review to determine whether the Eighth Amendment or Article 1, Section 9 guarantees a right to an appeal. Now, I heard my friend say there is no right to an appeal, which I think should end that question. He says the Equal Protection Clause is somehow tied up in the Eighth Amendment. The entire basis for that is a 1972 concurrence from Justice Douglas. It is not the law in the Supreme Court. It is not the law in this court, and it doesn't make any sense. The Eighth Amendment and Article 1, Section 9 speak to punishments. They don't speak to procedures. So to try to fit this case into the Eighth Amendment rubric, he says that denying the right to an appeal is a punishment. But if that's the case, so is every other procedure that governs post-trial, the post-trial management of a case upon a conviction and sentence, page limits, the deadline for filing a notice of appeal. All of those things would constitute punishments that could be challenged. Now, they might be upheld, but they would still constitute punishments. That is not the way this court or the Supreme Court has ever talked about the matter. Further, let's assume it's a punishment. Even if it is a punishment of sorts, it wouldn't be a cruel and unusual one. Cruel and unusual punishment is a very high bar. The U.S. Supreme Court has held that the electric chair doesn't count. I would submit that if the electric chair is not a cruel and unusual punishment, neither is the denial of a right to an appeal of a judge's exercise of discretion when you can seek review through mandamus or writ of certiorari to the U.S. Supreme Court. So I think where all this leaves us is with two possible ways to resolve this case. The first is to say the felony appeal law doesn't permit appeals of a judge's exercise of discretion. And we don't have to decide, we can leave for another day, whether the court can review a constitutional flaw in the sentence. If that's the case, the only option here is to affirm because he has not argued that the sentence was imposed unconstitutionally. Alternatively,
What's would be the General Assembly's motivation or the state's motivation for having unfettered discretion of the trial court in this instance, not to be reviewed by an appellate court? What public policy is served by that?
the public policy is the same one, I think, that motivates the Supreme Court's death penalty jurisprudence, which is that death is different. When you as an adult take another human life, the U.S. Supreme Court said, you engage in a crime that's different in kind, not simply in degree. And so because of that,
But we have appeals all the time where people have taken other people's lives and they're sentenced to consecutive sentences. We review those and still a life is taken. What's the difference?
So, and so that's step one, is that this crime is unique in its severity. And because of its severity, and this is where I get to the rational basis, no version of a life sentence will ever be problematic. If you take a human life, you have no legitimate grounds, except for the extraordinary unconstitutional bases we've been discussing, for complaining about a sentence of life without parole versus a sentence of life.
But Counselor, we have sentences all the time where after consecutive services there, we have, 50-year-olds being sentenced to 80 years in prison. That's life, right? And we review those and there's no death involved.
Right. I think the death involved is the death involved in the fact that every sentence available to this person is per se legitimate is what makes an appeal a waste of judicial resources. And that's the rational basis. Now,
Counsel, every murder is terrible. I'll give you that. But what are the facts in the record that support the most severe penalty short of the death penalty in this particular case? Why was Mr. Kinney, based on this factual scenario, considered the worst of the worst?
Well, Mr. Kinney's crime was premeditated, and let me explain how we get to this particular sentence and what the trial court said. He lured a person he loved, admittedly, back to a home with the intent to kill him. That's what the jury found. It found aggravated murder. He then murdered this individual whom he loved. If you can take the life of someone you care deeply about, you're particularly dangerous and the crime's especially heinous. Now, not only did he commit the murder, but he carried on with the rest of his day and went about trying to cover it up. He was texting with friends in a jocular way. He went home with his family. He helped his wife dye her hair. She said there was no sign that he was nervous or otherwise troubled. Again, a sign of a dangerous human being. Then what he did is he went back to the crime scene with his wife and their child, a young child, to have them come upon the body to make it look as though he had discovered the murder and not taken part in it. Then what he did is to try to set up 3 more people, one of the victim's previous boyfriends and 2 other people who had, I believe, built a fence on the property. Then he set about lying about it for 2 days in furtherance of this scheme before it was eventually busted. And so what the court said is that showed someone who is particularly cold, particularly calculating, and is going to be a danger to society at any age. That's why life without parole was imposed.
And there are those who would say he should have gotten the death penalty.
Well, the death penalty wasn't sought, but
Exactly. Therein lies the issue. You have the discretion of the prosecutors, one person, oftentimes, and then the trial court judge. And so had the death penalty been sought and he had been convicted and sentenced to death, he would have an appeal, correct?
He would, because we specifically provide for that. The reason being, frankly, the U.S. Supreme
And with the exact set of facts, the exact same set of facts, what makes the scenario different other than how the prosecutor chooses to prosecute? And
So
then,
here's the key. Oh, I'm sorry.
no, go ahead.
The key difference is that under U.S. Supreme Court case law, even as to murderers, the death sentence may sometimes be unconstitutional. There is no circumstance in which life without parole, as applied to a murderer or any life sentence, is unconstitutional. And so for that reason, there's no need for this prophylactic to prevent the imposition of an unconstitutional.
You say there's no scenario, and yet you say earlier that a defendant has the opportunity to file a writ of mandamus or some other higher hurdle for review that might be deemed, where a trial court's decision might be deemed unconstitutional.
So
It's
let
a
me,
different mechanism.
I'll try to clarify my answer. Aside from the circumstances in which the sentence is imposed unconstitutionally, which has nothing to do with the sentence itself, but the way in which it's imposed. Aside from those circumstances, which will all be resolved through mandamus, I think easily, there is no circumstance in which someone convicted of aggravated murder can complain about a life sentence.
How do you say easily if, like you said before, some unlawful reason, age, race, etc., is not set forth by the trial court, and it's just that trial court's judge's own biases that never come out on the record? How is that proven in a mandamus action?
It would be easier to prove in a mandamus action than a direct appeal, because the mandamus action, this court could order a brief from the trial court. If it's not on the record, that's a hopeless appeal. It would have to be post-conviction relief. So that circumstance will never arise in a direct appeal. But I see my time is running up, and I just want to suggest 2 possible ways to affirm this. One, and the one, or resolve this case. The one we advocate for, most obviously in the brief, is to simply hold that there is no constitutional right to an appeal, full stop. But if the court doesn't want to go that far, I think, Justice DeWine, your questions suggested one possibility, which is to leave open the question whether the felony appeal law would permit an appeal of an unconstitutionally imposed sentence or one that has constitutional flaws, and simply say that at least in cases where no unconstitutionality is the basis for the appeal, you can't challenge the choice of discretion between life without parole, life with parole after 20 years, 25, or 30. And if there are no further questions, we ask that you affirm this evidence.
I have one question. Prior to 2953-08's enactment, Could someone challenge a sentence on constitutional grounds?
So when we looked for this, we found cases where it was done, but no assessment of jurisdiction. The court has said that the general appeal law, before the statute's enactment, you couldn't challenge a felony appeal. And so I think the answer was no, although sometimes it happened. Thank you, Your Honors.
Thank you.
Your Honor, just a couple quick points.
Counsel,
First of all-
used your time. You may take a minute.
Thank you, Your Honor. A couple quick points. First, this was never a capital case, so the capital specs and the additional sentences that my friend referenced as providing additional sentences, discretionary sentences, are not applicable. I will tell the court, having been there, that the state of Ohio did not make a recommendation of LWOP. In fact, the elected prosecutor showed up for the sentencing and stood moot. Other than a general statement, the trial counsel did not participate in the sentencing hearing. I would also tell you that what the state seems to be suggesting is they want the court to rewrite D3 in a way that fits its policy narrative. That is left for the General Assembly. I don't believe we can go down that road. And then finally, there's no question that Mr. Kinney made some grievous mistakes, but even if you take everything, this all happened in a 16-minute span of time. There's no evidence he brought a gun. There's no evidence that there were threats. Most of, quite from my position, most of the trial court's conclusions, if you will, had no bearing with what was actually proven. In fact, the forensic evidence in there left grave doubts. It proved conclusively that the crime could not, or the shooting could not have happened in the way Mr. Kinney ultimately, quote, confessed to. He said that after there was an initial argument, pushing, shoving, a shot fired, and Mr. McGarry fell, he then stood over him at 6'6" and fired one shot in a split second. Physically, that was impossible. There was the forensic evidence showed that the bullet wound in the back of the head had to have been fired from close range, and the second shot almost missed. It just went between the scalp and the skull, which would indicate, given all of that, that there was a struggle involved. This was not an execution-style killing. Now, again, we have to live with what he did after the fact, but that's the point. It's all after the fact. There is no indication in his record or in his history, even if you think he deserves, say, 30 to life. But I guarantee you that if we brought his record from prison right now, he is a model prisoner. There are no issues. There is no need to protect the public from Mr. Kinney long term.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.